All right, well, we'll stay with that story then of Deputy Chief Justice Raymond Zondo and that response that is given, clarifying the historical ties between himself and the former President Jacob Zuma. Let's take you now to Professor Richard Calland. He is with the Department of Public Law at the University of Cape Town. Professor Calland, good evening. When you take and look at the test, the test for bias here and what would need to be required or fulfilled in order for Judge Raymond Zondo to recuse himself from presiding over this commission, does the relationship here, is that enough?
Well, thank you very much, Kathy, and good evening to you. I think the short answer is very, very short and very, very simple. No. What Jacob Zuma, through his foundation, alleged some weeks back was that there was a serious conflict of interest which would justify a recusal by Deputy Chief Justice Zondo. What has emerged today now from the Deputy Chief Justice, inevitably and appropriately, is a description of some facts which don't even come close, in my view, to being a conflict of interest. A conflict of interest is a particular legal meaning. It means when there is competing interests that collide, and where, in this case, the duty of the judge in terms of presiding over that Judicial Commission inquiry, the State Capture Commission, collides with his duty to somebody who is implicated. Now, where is the duty to Jacob Zuma? There is none. The fact there is this rather distant, rather historical link between two women who happen to be sisters is immaterial. It's deep in the mist of time. But Kathy, there's a second point here, which Justice Zondo touches on, but could have gone much firmer. And that is that there have been ample opportunities in the past for Mr. Zuma to raise this problem. He's appeared in front of this judge, Justice Zondo, on many occasions. That's the first point. Secondly, he was appointed, Justice Zondo was appointed by President Zuma to be the Deputy Chief Justice. The list goes on. Why was this problem not raised then? The answer is because it's not a problem. It's a fabrication.
So when you look at the previous cases that the Deputy Chief Justice lists, and it also includes the matters that involve the former president, which he presided over at the Constitutional Court, do you think that that history of cases and him making decisions that have a bearing on the former president would be enough for him to substantiate why he wouldn't recuse himself?
It's certainly a very strong argument, because if there is a serious reason for a judge to recuse themselves from a particular case, it's a requirement either that the judge themselves observe the protocol and recuse themselves voluntarily, or somebody who's a litigant in the matter would have to raise the point and present it to the court. Now, in this case, there would be no reason why Justice Zondo would recuse himself, because there is no conflict of interest. There's no reason for him to even consider a recusal, in my view. And on the other side of the coin, Jacob Zuma has never once raised this matter until now. And it's clearly, in my view, a sign of his desperation. He knows that he's running out of runway. He knows that the net is closing on him and his network. And therefore, he's really clutching at straws to try and discredit this commission in the eyes of the public.
Richard, the former president has been given the 16th of November as one of the dates of which he must appear before the commission. As yet, his lawyers haven't filed this formal application for the Deputy Chief Justice to recuse himself, but should they do so, it would have a bearing on whether or not he appears. And, you know, there seems to be a lot of thinking, a lot of strategizing behind the scenes. How long would an application for recusal take should it come before the commission, let's say, on the eve of his appearance? So should the Deputy Chief Justice receive this application on the 15th of November?
Well, the facetious answer is about 10 minutes or less, in the sense that the Deputy Chief Justice has made his position clear now. He's basically saying this is nonsense. There's absolutely no conflict of interest. There's absolutely no reason for me to recuse myself. And that would, I think, be his immediate response to any application made formally by Zuma's lawyers to the Commission. However, what then might happen is, once they've taken that decision, in line with probably 15 years' worth of legal strategy, sometimes known as the Stalingrad strategy, Jacob Zuma and his lawyers might then judicially review the Commission of Inquiry on the basis that this has been a mistake in law and an error that is unlawful. And they could then use that as an excuse to further delay his appearance in front of the Commission of Inquiry.
Let's talk about that judicial review. My understanding was that a judicial review of an inquiry such as this one can only happen once, the judge has made his findings and the matter's effectively been dealt with. But if you're saying that they can effectively bring an application like that during the proceedings, what does it mean for the actual proceedings?
Well, I think the argument that would be put by Jacob Zuma and his lawyers would be that the proceedings are tainted, that they are in effect null and void insofar as they relate to Jacob Zuma. And so they would bring an urgent application, I presume, to stay the Commission of Inquiry. And what the Commission of Inquiry no doubt would do would be to hit back very hard and say this is nonsense. They would hopefully the matter would be expedited quickly. The court would rule, I would think, very quickly and very clearly that there is no need to recuse. The decision not to recuse, if that's what happens, very likely, was a lawful decision. And then the Commission would continue on its way. But it's another delaying tactic, Kathy. It's nothing more than that. It's a delaying tactic to put off the inevitable.
Richard, how long is this likely to last? And I mean, I know you're basically working speculatively here, but the Commission is nearing the end of its term, and it cannot afford any more delays.
Well, that's right. And so that, no doubt, is in the mind of Jacob Zuma and his lawyers. They are trying to push this as far out as possible. They're trying to make it as difficult as possible. And, of course, it's disingenuous. Jacob Zuma is very fond of saying that he is keen to have his day in court, but he's also, in terms of his actual actions, very determined, and has been for 15 years, to, in fact, avoid any sense of accountability. And his strategy is to avoid justice. It's as simple as that, to avoid accountability. And it's beholden on the institutions of this country and the rule of law to hold him to account. And clearly that is beginning to happen. The net is closing, as I say. This is a desperate measure by a desperate man at the end of the runway.